Learned trial court did not accept the bail, my lordship. Only satisfaction, yes, lordship. Only satisfaction of the learned special court under POCSO Act, Jalpaiguri.
কি হবে?
ওটাই হবে, ওটাই হবে।
ওই ইনক্লুডিং করে দাও না। হ্যাঁ, নেক্সট।
My lord, I beg to appear on behalf of the petitioner. My lord, I have yesterday served the copy, my
My
lord.
lord, we got the copy yesterday, but we need this case diary, my lord.
টুমরো
My lord, kindly keeps it on
থার্সডে,
Thursday, my lord.
ফার্স্ট।
Grateful, lordship.
My lord, I appear for the petition.
Lordship, apology, Lordship, the case diary is on its way.
পাস্ট ওভার।
My lord.
নেক্সট।
My lord, I am for the petition. My lord, service is yet to be completed. My lord, let there be a direction upon the state to serve the copy. My lord.
Let us see the statement. Who's for state? 4.
Item number 4.
Subhasis Mishra is the lordship.
Passed over. Not all of them.
Item number 5.
Lordship, praying for should pass over.
Pass over. Okay, pass over. Next.
Item number 6.
Lordship, praying for should pass over.
Who will appear? Short pass over?
Lord Council, he is on his way, Lordship.
Who's
Kindly
the
short pass over.
lawyer?
Joydeep Kanto Bhowli.
Joydeep Bhowmik is not here. All right, passed over. Bujo.
Item number 7.
No time for the petition, my lord. My lord, on 22nd of this month, my lord, who was granted bail by your lordship, I am standing on the same footing, my lord.
Different footing.
My submission, my lord, kindly think about that. My lord, dashing the police vehicle and fled away, and case of firing an empty garbage, and no one arrested from the spot. My lord, kindly see the order passed by your lordship.
Yes. Yes, Mr. Niloy.
My lord,
Tell us how it is.
এটা কি নাম যেন?
My lord, there are two petitioners before your lordship, my lord.
Ashish Giri.
Yes.
My lord, Ashish Giri, and so their bail application was rejected on 14th of November 2024, my lord. And they were arrested, one was arrested from Motorist in Hotel, which is nearby 13 kilometers from Jalpaiguri, and another from Kisanganj.
All
So
right,
they were in the spot, my lord, while
petitioner.
they were chased
is
by
in
the police.
custody for
My
petitioners.
lord,
are
one custody for 164 days.
Both.
The person who was granted bail, he was arrested from UP, my lord. He was not in the spot, but they were in the spot who was fired the police personnel.
Petitioners were are in custody for 164 days. They submit there is no direct evidence connecting them with the crime. Co-accused has been enlarged on bail. Accordingly, they renew their bail prayer. Learned lawyer for state content, petitioner and others dashed a police vehicle. When they were chased, they fired at police personnel and escaped. Petitioners were arrested from near the spot, whereas co-accused Ashish Kumar Jadhav was arrested from Uttar Pradesh. We have considered the materials on record. None of the police personnel identified the petitioners as miscreants who fired at them. Full stop. Involvement of the petitioner is based on circumstantial evidence. Investigation is complete. No firearms were recovered from them. Involvement is based on circumstantial evidence. Investigation is complete. co-accused has been enlarged on bail. Accordingly, we extend the same privilege to the patients. Next. 13. 13, where is the report of the Commissioner of Police?
But 6 or 13 are 6 and 13.
You are late, now wait.
No, 6 or 13 are same. 6. দুটো একসাথে রাখতে বলছি।
So this man has not done anything.
Malad,
Who is this Moksedur Rahman? So what has he done? First thing we wanted is a clarification of the cause of
Yes,
death.
yes, my lord. This is the my lord. This is the investigation page, last page, my lord, of the case diary.
Yes, we have seen the last page.
No, my lord, in the case diary, my lord.
What did we want a clarification from?
Yes, my
Is this suicidal?
my lord. Already, prayer has been made.
What prayer? You want the doctor to be also brought before us?
No, no, no.
Prayer. When we have fixed this matter today, we wanted the report of the doctor as to in regard to the nature of injuries, whether there is a possibility of suicide or it is indicative of a homicidal death. What prayer? How far is North Bengal Medical College from this officer's office?
Not IO visited the HOD of the
Then?
particular.
Why the HOD was not informed that today we have fixed this matter
Head of the-
before us?
FMT head of the department, he visited the meet with the doctor and consulted, and the doctor who conducted the postmortem is now.
Doesn't matter who conducted the postmortem. We don't require the doctor who conducted postmortem. We require a medical professional to say whether in view of this nature of injury, the possibility of suicide appears to be remote or not. If this is the commissioner, acting commissioner, assistant commissioner of police's competence, we would have to recommend him for suspension. He needs to go back to police training college for investigational purposes. He needs to learn investigation. We don't pass orders for lip service. We don't pass orders for lip service. We keep this matter tomorrow. And by 24 hours, we need clarity. Who murdered this lady, girl? Perused report submitted by Assistant Commissioner of Police, TRF headquarters, Siliguri Police Commissionerate. The report is extremely vague and evasive. It does not clarify whether Tiasha, whether the petitioner's daughter, Tiasha Sarkar, who died due to whether the death of petitioner's daughter Tiasha Sarkar was due to was suicidal, homicidal? Was homicidal or not? Full stop. Other aspects pertaining to the whereabouts of the de facto complainant at the time of occurrence.
So that has been mentioned.
Where?
From the last page of the case diary, point number 2. And the CDR also collected from where we can see he was very much present within the tower location of the house of the de facto complainant. That is already evident.
Tower location, who was present?
De facto complainant.
So in his house, he was present in and around his house,
In around this.
right?
Yes.
So what about his neighbors? What do their neighbors say? Who are his neighbors? Tower location is about half a kilometer,
About half.
is it?
Yes.
Do you know what is called a lat-long report? Huh?
Yes.
The device's coordinates are best determined by a latitude longitude report with regard to the location of the handset. So isn't that a more certain feature with regard to the PTA de facto complainant's position? If you are determining through electronic evidence on a presumption that the mobile phone was always being carried by him? Where is that?
That is not.
Where is the oral ocular statements of witnesses in and around the spot with regard to his presence?
That is not.
Then who is going to advise an assistant commissioner of police? If an assistant commissioner of police requires advice on investigation, what about the police stations manned by sub-inspectors of police? This is the quality of investigation the state provides for the citizens. Death, 2 people died. You are not clear. You are not even clear whether the deaths are suicidal or homicidal. We don't find any clarity. So with regard to the whereabouts of the de facto complainant, investigating agency did not undertake any local investigation. On the contrary, CDR of his mobile phone was collected. CDR indicates tower location and gives a wide-ranging approximation with regard to the area where the mobile phone was operating. Even then, no latitude-longitude report of the device to give a more accurate position, to give a more accurate status of the device, accurate position is placed on record. We record our deepest, we record our dissatisfaction in the manner the Assistant Commissioner of Police, a senior police officer, has undertaken investigation. We direct him to take immediate steps in the immediate steps to collect evidence and submit a more detailed report by tomorrow. Matter will appear tomorrow.
My lord, I had an interim protection, my lord. If that may continue, my lord. As of now, your lordship has seen my complicity, my lord. If I may
Your
request,
complicity is based on the suicidal note.
my lord, which
And our estimation is, in all probability, the lady murdered his daughter and committed suicide.
my lord, there is no
There is a
allegation
possibility.
of me pressurizing the daughter of the lady, my lord.
Does
with-
not matter, you pressurize the lady.
Well, there is a previous
and
complaint.
your Joydeep Bhowmik, your case,
My lord, I am in custody since the 43 days,
same, you are named in the suicide note
as the last portion.
and the last portion.
Well,
We'll examine
My lord,
that.
may I just request one thing, my lord? My lords will see the suicide note once.
We
my lord.
will see everything.
So, my lord, till such time, my
We
lord,
will see everything. We are keeping this tomorrow.
please, my lord, kindly extend the interim order, my lord.
You already have an input.
No, my lord, that was, my lord, last time my lords were not inclined. My lord, I was doing online, my lord, there was some. So let that interim order be extended till tomorrow, my lord.
Next.
My lord, may I just request, my lord, kindly appreciate, my lord, it will be infructuous, my lord.
All right, we'll
Well,
see.
My lord, kindly extend it till tomorrow,
We'll
my
see,
lord.
we have
My
indicated.
lord, we'll
47.
abide by the decision, my lord, which will
Yes,
ultimately be
yes.
passed, my lord.
The-
My lord, kindly extend the interim
Everything
order.
will be passed. We ask your
Yes,
officer,
yes,
or
yes.
otherwise, tomorrow, we'll ask the Commissioner of Police to be present on Friday. If effective investigation is
Yes.
not made.
Case data দেখুন।
Don't cover persons who do not deserve to be covered.
Yes.
Bring out the truth. How this incident occurred? We want to know.
My lord, may I just request
Yes,
once
Mr.
more, my lord?
Bhattacharya, we will pass all protection tomorrow. Let us first get the clarity.
So, my lord, orally, my lord, if they give an assurance that they will not arrest me till
Let
tomorrow,
us
my lord.
see next.
Because my otherwise it will be infructuous, my lord.
My lord, 6 will be fixed on tomorrow, my lord.
6th and this matter tomorrow.
But with your losses liberty, my lord, I will join online tomorrow, my lord. Oh, blessed well.
I am for the state lordship.
ওখানে একটা লাইন দিয়ে দাও, if effective investigation is not undertaken, this court would be constrained to direct personal appearance of the Commissioner of Police for clarification. Copy of the order be communicated to Commissioner of Police. Yes,
Lord, the victim was informed and she is present before your lordships.
you are for it. Let us see the statement of the victim.
164 statement of the victim lady at page 25.
Yes, Miss. What is the age of the victim? What is your client's age? Petitioner submits there was cohabitation between two adult persons. They pray for, accordingly, he prays for ancillary bail. Learned lawyer for the state opposed the prayer. Learned lawyer for the de facto complainant contends. Petitioner has refused to marry his client. We have considered the materials on record, including the statement of the victim. In her statement, the victim claimed she was, there was an intimate relation between the parties for last 4 years. 1 year ago, petitioner had persuaded her to abort the child. However, it is unclear whether the cohabitation was on the false promise of marriage was out of romantic love between the or on a false promise of marriage. Mere refusal to marry, subsequent refusal to marry per se may not constitute an act of deception. Under such circumstances, we are inclined to grant custodial interrogation for progress of investigation not necessary under such circumstances. Grant answer. Next.
I'm grateful to you. Still the-
But in this case, my lord, last date, my lord, court was pleased to
Yes.
fix this matter today, my lord. Already, four more persons were arrested. Out of four, two, here is the petition number 1 and 2 already arrested.
What about the others?
My lord, they are still absconding.
What steps have you taken with regard to absconding accused?
The report, my lord.
What steps have you taken in respect of an absconding accused when in December 23, the
Yes,
prayer for anticipatory bail was rejected?
already, my lord, the prayer also not made before the
Why not?
decision
Why not?
for WPA.
First, to WPA, you should not pray together. Huh?
Yes, ma'am.
At least lawyers should not say that.
Yes.
Hmm. So,
Hmm.
why steps have not been taken? So that they can negotiation go on between complainant, police and accused. Huh? Do you want their arrest? If you don't want their arrest, why oppose the prayer? Say we don't want arrest. It's not that every case you require arrest, investigation purpose arrest is not even required. Report is placed on record. Investigation officer is present. Report is placed on record. Report shows petitioner number 1 and 2 have been arrested. Others
Along with two others.
are absconding. Investigating, it is open to the investigating officer to take appropriate steps for their apprehension in accordance with law. There is no substantial change in circumstance since the rejection of prayer for anticipatory bail of the other petitioners. Accordingly, the application is dismissed. Proceed. Next.
Follow.
60 minutes I'm for the petitioner. Promise to marry me. Last time loss of direct communicate.
Last,
Victim notified.
yes, ma'am. Victim notified last day, she also present before this court, madam, but today not present.
Why any lawyer was not assigned to her?
On behalf of the victim.
Then what are you doing? What do you say?
Why not? The problem is that, well, but he's giving threats to the victim. And after the incident, for a couple of months, victim couldn't stay in her own house. She had to leave her house and stay somewhere else, my lord. Victim, the accused has quite high influence in the area, he has political influence, my lord.
Let us see the statement.
And my lord, in such a situation, it will be extremely unsafe for the victim if he's released on anticipatory bail, my lord. Victim is here, man. Right?
One second. 5 is in custody. He's the person who was present in the vehicle.
Yes,
And the other
17, no.
owner of the,
He was not to.
5. Record an order. Petitioner is in custody for 50 days. Your doctors and police officers are hand in glove with an accused. We make it clear, we will pass strictures against this doctor and the police officer who obtained this report.
My lord, even in preparation of this report, my lord, I had to pursue, my lord, to
So
such an
that
extent,
is
my lord.
exactly why we will initiate disciplinary proceedings.
My lord.
Recommend initiation of disciplinary proceeding against them. This is the way in which you try to dilute a prosecution.
Lord.
Huh? There's likelihood of fall. If a fall from a high space takes place and 2 children are uninjured,
Exactly.
doesn't it rule out the possibility of a fall? This is the area of investigation. We are amazed. We don't preside over Punch and Judy shows. We don't preside over dishonesty and cover-ups. We preside over honest endeavors to unravel truth. That may help Mr. Bhomik's client, may not help Mr. Bhomik's client. That is least of our concern. But what is important is truth must come out. And this is how truth comes out. 2 children, 3 children are in a toto. The defense version is toto turns over, falls, and 1 child suffers injury and dies. We ask 2 questions. Are there injuries on the other 2 children? And whether there is a possibility in this factual background that the nature of injury is suicide through a road traffic accident. You come up, yes, there may be a possibility of a road traffic accident. This is the report. Then file a police report discharging him. File police report discharging him. You have the police department sitting in the office of the accused. Let them dictate how reports are to be prepared.
Lord, may I propose one thing, Lord? If the same opinion may be taken from a medical board, my lord,
We will
consistent-
not require any opinion, sir. We will say that this doctor should never be permitted to give any opinion in a medical legal case. All right. For 50 days, he submits. The victim boy suffered injuries due to road traffic accident and died. Accordingly, he prays for bail. In light of the aforesaid submission, we directed, learned lawyer for the state opposed the prayer. He contends that the victim petitioner had taken away the victim and his 2 siblings. That is, what are the names?
Gublu and Momita and Gublu. Momita and Gublu, my lord.
They are sisters and brothers of?
No. Neighbors.
And 2 other children, namely Momita and Goblu, in his toto. Thereafter, he murdered the child. Injuries, in light of the rival submissions, we considered the rival submissions at the bar. We also noted extensive injuries on the deceased. In this backdrop, we directed the investigating agency to submit report whether Momita and Gublu had suffered injuries or not, injuries in the course of the incident. Medical opinion was also sought whether the injuries on the deceased may be due to road traffic accident. Report is placed on record. Report of the investigating agency is placed on record. Is placed on record. The reports show the other two children, Momita and Gublu, had not suffered injuries. Medical officer opined that the injuries on the deceased are produced by impact with hard and blunt object over anterior wall. Over anterior wall, abdominal wall, full stop. He further opined fall from vehicle over hard surface may produce such injury. However, the opinion was tentative and the officer and the doctor stated that investigation ought to be made regarding circumstantial evidence. In this court, needless to mention, opinion of a medical the medical officer's opinion. Needless to mention, medical opinion with regard to cause of injury is a tentative one. The officer clarified that the actual cause must be investigated on strength of circumstantial evidence. A significant circumstantial fact is the absence of injuries on the other occupants in the Toto, that is Momita and Gublu. Had the Toto suffered an accident, had the Toto met with an accident, the other two children in the vehicle would also suffer injuries. This improbabilizes the defense version with regard to injuries arising out of road traffic accident. On the other hand, the injuries are caused by a hard blunt substance. Injuries are caused by a hard blunt substance, and the petitioner was the only adult person who was present when the injuries were caused. In light of the aforesaid incriminating circumstances and gravity of offense, we are not inclined to enlarge him on bail.
Grateful.
We express displeasure with regard to the quality of investigation, quality and nature of investigation undertaken, investigation conducted by the police officer. In spite of repeated directions, notwithstanding direction passed by this court, the investigating officer was most reluctant to conduct a fair and impartial investigation, and even went to the extent of relying on a tentative opinion of a medical officer who had clarified that the said opinion required to be verified, required to be vetted through circumstantial evidence. we record our displeasure in the manner of conducting the investigation. We having recorded such displeasure, we direct the Commissioner of Police, Jalpaiguri Police Commissionerate,
Lord, SP Jalpaiguri.
Superintendent of Police, Jalpaiguri District, to transfer the investigation to a superior police officer who shall conduct the same in a fair and impartial manner. Full stop. It shall also be open to the Superintendent of Police shall take note of the aforesaid observations and and initiate appropriate proceedings against the police officer conducting the investigation in the case. Rejected. Now, 15. 17. Petitioner contents he is the owner of the Toto, which was used by co-accused, which was driven by the co-accused. He was not present at the spot when the incident occurred. He prays for anti-tribute. Learned lawyer for state submit prayer of bail prayer of the Toto's driver, that is so and so, has been turned down. We have considered the materials on record. One, Vishnupodo Sarkar was driving a Toto belonging to the petitioner. He had taken the deceased, deceased along with two other children, Momita and Gublu, were in the Toto. Taking advantage of the situation, he assaulted the deceased child, resulting in severe abdominal injury and death. Petitioner is the owner of the Toto. He was not present at the spot. Under such circumstances, we are of the opinion custodial interrogation of the petitioner is not necessary, but he requires to cooperate with investigation, meet the investigating officer once. I'm grateful. Yes, next matter.
He received a phone call that his father has been ill. And
Not today, not today.
Lordship, during the course of the application being pending, I have received one application summons from the civil court. They have filed another civil. So I brought it with.
Place it on record. Supplementary affidavit is placed on record. Copy is handed over to learned counsel for the de facto complainant on the prayer of the de facto complainant adjourned for the day. Mr. Honorable Bishop, some further documents have been.
I have been served.
Tomorrow. Next. Nineteen.
I'm for the state.
I'm for the petitioner, my lord. I'm for the victim. My lord, this case is initiated outrage of the broken relationship and the FIR lying in the page number 13 and para number 6 of my application.
Yes, statement.
Itself cleared the
Statement and the medical report is here.
Page.
and I was all right. My lord, may I? My lord, I was informed by the petitioner that there is a reconciliation
long-standing civil dispute, 12% have been FIR named. Out of 12, 3% has been granted anticipatory bail by the learned session judge. My counter FIR is as page 17 to 19, my lord.
Yes,
Severe injury, my lord. Dislocation of the X-ray report is also there.
we have
Hello.
considered the materials on record.
We also
There
suffered the
is a
injuries,
civil dispute between parties. Case and counter case have been registered. Though injury is grievous, it appears, it appears incident occurred on the spur of moment and was not a premeditated one. Accordingly, we are inclined to grant anticipation. Other matters will take up after 5 minutes.
Item number 3. Worship, the IO has gone to the trial court to procure the CD, so.
Why I has gone to trial court?
The CD is with the trial. court.
I get a photocopy. No original CD is
Yeah,
not.
Gurgaon police also
Not today.
Lordship, kindly place the matter on Thursday.
No, sir. First we'll reject because you are disrupting trial. Right?
I'm holding the case. There is
This is the case under section 363, 361, section 4 of the POCSO. Petitioner is custody for 217 days. Charge sheet has already been submitted. Victim girl is refused his medical examination.
Girl has been recovered from the Haryana. Let us see the statement. 164 is there, my lord. Kindly, my lord.
He went with me with our own will.
Let us see what he says, what she says.
27, ma'am. 27, 28, 29, 30, my lord. 17 years, my lord.
Victim is 17 years, I am 22 years, my lord. 16 charge sheeted witness, my lord.
Give notice to the victim. Friday.
Let
My lord. I want you to see that.
No, yeah, this is going together all over the country. Western UP and Western Eastern also. Worst. The most.
Item number on the ground of Mr. Shaha Poddar, I am praying for 1 day accommodation, ma'am. Good.
Item number 10.
I am for the petitioner, my lord.
Worship, notice
In this case,
complainant, victim and I all are present.
well, allegation is section 8 of the POCSO Act, my lord. Allegation against the
Well, as I have served the copy on the Friday. I do not know state is prepared on. Well, it's a conviction under section 302 and 498A. I was all along on bail. I did not disobey the conditions which has been given by the trial court. Well, as there are two principal witnesses, eyewitnesses. On their statement, the conviction has.
What was their age at the time of occurrence?
Well, one was 3 years and another one was 7 years. And he has taken full care of the children while he was on bail. Today, the eldest son is 17 and the younger is around 12. They are studying in schools.
You have considered the evidence of PW. About 106. Why is there eyewitness? How can 106 come?
PW4 and
4 also supported the case.
my lords, upon their statement only the conviction has tried. I have nothing. It's a mercy application because the incident has been narrated.
What is
at
the postmortem?
my lords.
Shock and head injury.
Right.
So it corroborates the.
Everything has been corroborated.
We
Very
have
hard to
considered
take
the
in.
evidence on record. PW3 and 4 are the minor children of the couple. They were present at the time of. We've considered appellant is the husband of the deceased. PW3 and 4 are their children. They were present at the time of occurrence. They deposed. They deposed that the appellant had hit their mother with had hit their mother on the head. As a result, their mother died. PM report, PM doctor proved the death was due to head injuries. In view of the aforesaid clinching evidence on record and the sentence being, and as the sentence is one of life imprisonment, we are not inclined to suspend the sentence. Paper book be prepared within 8 weeks of receipt of PCR. Trial court record receipt?
No.
Within
It
8
was,
weeks.
it was, yes.
Okay.
Last week
Next.
it was admitted.
Next.
Your lordship, in item number 22, I am appearing on behalf of the Customs Department as the respondent.
Very good. What is the delay?
31 days.
Delay is condoned, sir.
I am so.
We are condoning the delay.
But with respect to the bail application, I have objection.
First, we condone the delay. Delay is condoned.
Grateful.
Well, on the last occasion, there was a direction to serve on the DSG office, my lord.
All right. Delay is condoned. Appeal is admitted. Issue usual notices. Have you paid for bail?
My lord, I have not prayed for bail. my lord.
He has not paid for bail.
Oh, all right.
Call
Your
for
lordship, your lordship, the Customs Department, the name of the Customs Department has not been mentioned in the cause title.
It is filed with the Union of India, my lord.
make an
I
correction.
will do that.
Liberty to
Yes.
correct the cause title of the petition and describe the respondent as Union of India. Who is the complainant? Let us.
Lord, we'll have to give it to the
Customs,
superintendent of customs, my lord.
Union of
Superintendent of Customs, Naxalbari Customs Division.
through Union of India through Superintendent of Customs. Please give the particular.
I will.
And Naxalbari Customs Division.
Next.
Much of.
Yes.
Lordship, I'm on behalf of the appellant Lordship. It is a bail in connection with appeal Lordship.
It is
The
a-
allegations against me are under section 302 and 34 of Indian Penal Code.
All right, appeal is admitted, issue usual notices, call for TCR and liberty to pray for suspension of sentence upon notice to the state.
Grateful Lordship.
Next,
24, my lord, it's a old matter, my lord. The petitioner is already on bail, my lord, as I have heard from Mr. Bhumik. And CRAN 2, my lord, is a supplementary affidavit, probably.
dismiss for default. Dismiss for default.
Great.
Next.
I am for the petitioner. Co-accused standing on the same footing enlarged by your lordship.
All right, restored. We have a petitioner is in custody for
660, more than 600.
660 days. Co-accused have been enlarged on bail. He stands on the same footing. Accordingly, we are inclined to extend the same privilege. Next. 26.
For the petition, it's an application for restoration. Your lordship is pleased to direct the case diary to be.
Case diary.
Your lordship. So this is the case lordships give a direction.
Your lordship has already gone through the.
And thereafter ACP is directed to take cognizance against the ADS or Kujbihar. They are making a false deed and thereafter all are conspirator and they are your lordships one of the conspirator. And he is the one is the deed writer, witness to he
My lord, kindly comes to page 11 of your lordship's brief first.
Page 11.
It up to 11. After your lordship's order on 24th of May 2024, the petitioners, they have surrendered before the learned trial court. They have surrendered by their own. And now they are in custody more than 84 days. And on the last occasion, even my learned friend has pleased to address before this honorable court. This sanction proceeding is still pending.
How long they are in custody?
Well, we are in custody for 84 days.
Hey, 84 days is nothing.
All are on 84 days, the lordships. And lordship kindly
Charge sheet has been filed.
No. My lord, kindly sees the direction of this honorable, kindly sees the order of this honorable court, giving bail to other co-accused persons who has been stated as a principal conspirator to the.
Where is the order?
My lord, that's the. I have handed. Kindly sees the observation of this honorable. And he has been granted bail in 60 days only.
616 days.
Yes.
Then.
But my lord kindly considers
No,
the
sir.
observation
No,
of this
sir.
honorable court.
No, sir.
This kindly considers that he is the principal conspirator.
Maybe.
He was the person
Now you
who
wait for-
employed. He took over everything.
I
And
think,
eventually,
alright.
your lordship's direction was given in the month of May. They did not comply with till date.
That gives you a ground for release on bail, huh? No.
Let's kindly seize our role. I am the typist, I am the law clerk, and two others are my employees.
How long are they in custody? This person?
Surrendered for 4th November.
No, Anupul Rai?
Same your lordships. Same.
Same. 60, they're not 660.
No.
Yes, how are they different from Anupul Rai?
No different, your lordship.
No different.
As because lordships, deed writer, student, deed writer, here is the
typist, student,
Well, petition number 3 is the
Tuhin
typist.
Adhikari, witness, attested, and clerk of Tuhin Adhikari. All are along with it is a gang, your lordships.
Yes,
But-
what is the role of this person?
One of the petition number 3 is the typist, professional typist. Petitioner number 1 is the law clerk. Petition number 2 and 4, they are the employees of petitioner number 1. Even my lord, during the investigation, we have not been taken into police custody. We have not been asked for any interrogation by the prosecution.
Now, Mohendra Rai, how is he connected to the land?
Mohendra Rai lordships.
Sorry, not Mohendra, the complainant Sunil?
Actually, they are conspirator, one person
No, no.
died.
Correct,
Yes,
that is Mohendra Rai.
Mohendra Rai. And here the false Mohendra is working as a,
Sir, we are asking certain questions. How is the complainant related to Mohendra?
lordships, as because they are trying to,
How is the complainant related to Mohendra?
we actually the gang. They are the gang lordships.
Who is the complainant is the gang?
No, no, no. Complaint is the de facto complaint lordship.
Yes,
The father of the lawyer. Here,
father of the lawyer.
yes, sir, Kuchbihar Bar Association lordships. Manoj Rai, your lordships.
The
Mohendra is the
complainant is one Sunil Kumar Rai. So who is Sunil Kumar Rai? Who is Sunil Kumar Rai?
Thing speaks in the FIR.
This is a drama you are doing. Drama. Huh? You require 17A sanction for registering an FIR under 13(1)(d). Are you aware where 17A applies? Ask the police officer to be present.
Lordship.
What is this place? Is this a court?
Lordship, you
Is
know-
the police officers here?
Yes,
All of them irresponsible persons. Each one.
Giving them opportunity so that they get. Lordship knows better than us, Lordship.
You're trying to subvert an order passed by this court by giving a recommendation for sanction.
Yes, Lordship. Even Lordship's directions, they are just only they change the IO, nothing else, your Lordship, only they have to only 161, 2, 3 statements.
Deputy Superintendent of Investigating Officer is directed to be personally present and explain why he sought prior approval under Section 17A of Prevention of Corruption Amendment Act 2018 in the fact, which 18 in the instant case. Full stop. Let him give an explanation why. he did it.
They are not the complaint employees, so this is not applicable them, they are paid for bill, Lordship. This is the going on, your Lordship.
No, what is 17A?
Yes, Lordship.
No, yes, we know, yes, but do you know what is 17A?
Take a prior permission to the,
To,
to higher authority
For?
to take cognizance against the officers, government
is
officers.
that so? Are you aware what is 17A?
Lordship, may I?
You don't know even what is 17A. You don't know.
Lordship, Prevention of Corruption Act, Lordships.
We know
Section-
prevention of corruption, but what is 17A?
Yes, Lordships.
What is?
Lordships, permission to inquiry of the investigation of the officers relatable to recommendations made or decision taken by the public servant in discharge of official function or duties, your Lordship.
So where 17A applies? When a public officer makes a recommendation or a policy decision, does it apply when a public servant dishonestly registers a name in the land records? Is it a recommendation or a policy decision?
No, Lordship.
If it is not, then where is the scope of seeking a prior
Prior
approval
permission.
under 17 capital A?
Even though Lordships, you give a direction to take cognizance, change the IO, and now DSP is conducting the case. Even your Lordship, if you go through the CD, your Lordship, only the complainant, they are taking 160 statement, this much, Lordship.
The thing is, they inquired, and in the inquiry, they found someone had made the registration. Initially so and Lomin Dolma Lama,
Yes.
ADSR. And during her tenure, the land was registered and it was signed by her. Where is the policy decision taken? What is the recommendation made for which 17A will apply? She has, without following the relevant rules, registered an instrument where the purported executor is a dead person. Does it require 17 capital A? Then what is this police officer doing? He's trying to abort the
Yes, Lordship.
judicial orders passed by
Yes,
this.
Lordship.
Then
Lordship, he knows better than us. What is going on, Lordship?
we are not going to give you bail.
Lordship.
Kindly, what's it, role of mine.
Correct. Your role is being exacerbated by the corrupt role of the investigating officer.
But it's the principal conspirator, he's on bail.
We don't bother. We will not give you. We will ensure the suspension of this police officer and we will reject your bail.
84 days, but it's 90 days are supposed to be over.
Mr. Counsel, you should know where to press. You are digging your own grave. Understand? You should not have asked for restoration of this application at all. Next. কিছু করে রাখো না।
My lord, tomorrow.
27, appearing on behalf of the petitioner, your lordship. In this matter, your lordship, on the last occasion, your lordships had directed the Bhaktinagar PS to produce the opposite party number 2, that is the
Yes.
accused persons, your lordship.
She's present.
Who is she?
Uh, 28, same matter, your lordship,
Same-
same
same.
FIR, another accused person.
Who is the other accused?
One is the husband and another is the brother-in-law. The first case was murder.
Ask her, both the persons should be present tomorrow. And someone will be appointed on their behalf if they cannot have lawyers. And we will give them opportunity to file affidavits, all right? ভাসুরকে বলুন আসতে। Where is he? Let it be on late. Yes.
But I'm led by Mr. Mukherjee, my lord, and it's in
My lord, my lord, I appear, my lord,
Yes, Mr.
for the appellant here. My lord, my clients, my lord, are the owner, my lord, or rather, my lord, a lessee under the state in respect of a tea estate known as Tursa Tea Estate, my lord. My lord, the lease, my lord, is, my lord, for 30 years and, my lord, valid till 25th November 2035. It's an existing subsisting lease, my lord. There is no dispute with regard to that. Now, my lord, pursuant to, my lord, an incident which of, my lord, violence which occurred, my lord, at the tea estate on, my lord, the 10th of July 2024. My lord, there was, my lord, a declaration, my lord, of suspension of work on 19th of August 2024. My lord, the matter was communicated, my lord, to, my lord, the labor authorities, my lord, in 19th August 2024 itself, my lord, pointing out that there was, my lord, an industrial dispute. Now, my lord, your lordships are aware, my lord, that under section 12, my lord, of the Industrial Disputes Act, my lord, necessary steps, my lord, are to be taken for the purposes of conciliation. My lord, no steps, my lord, were taken here. My lord, suddenly we find, my lord, on the 17th of January, my lord, 2025, my lord, an MOU, my lord, is sought to be entered into, my lord, with the manager of a, my lord, nearby garden, and, my lord, some of the members of the trade union, my lord, seeking to, my lord, start work, my lord, in, my lord, the tea estate which belongs to me. My lord, I get to know about this on the 18th. I immediately, my lord, file representations, my lord, which are twofold with the state authorities. One, my lord, is to, my lord, complete the conciliation. My lord, usually, my lord, the outer limit, my lord, is 60, my lord, 60 days. And, my lord, it can be extended. My lord, we request, my lord, for that, my lord, to be completed quickly. And secondly, my lord, we, my lord, ask for, my lord, protection so that, my lord, the tea estate, my lord, nothing happens. My lord, no step is taken, my lord, in the matter. My lord, we, my lord, move, my lord, the, my lord, writ court, my lord, seeking, my lord, reliefs, my lord, with regard to, my lord, protection of my assets, and, my lord, with regard to, my lord, conciliation. My lord, the learned judge, my lord, the state appeared there and seemed to, my lord, support, my lord, the respondent number 7, who is, my lord, the outsider, my lord, on the basis of, my lord, one standard operating procedure which was formulated by the state, my lord, on the 6th of November 2024. My lord, be that as it may, the learned judge, my lord, heard us, my lord, all at length, and, my lord, passed, my lord, the impugned order. My lord, just two aspects of the impugned order I wish to address your lordship, my lord. Kindly take, my lord, the memorandum of appeal. The impugned order, my lord, is an annexure there. My lord, the first finding, my lord, is, my lord, your lordship will find at page 2 of the impugned order that, my lord, the lease is subsisting and not yet determined. My lord, it's in the second paragraph, my lord. Your lordship will find that. Then, my lord, the contentions of all the parties, my lord, are recorded. Findings, my lord, start, my lord, at page 5. Kindly come, my lord, to page 5. Now, my lord, kindly, my lord, if I may just place that portion after, my lord, last 4 lines of page 5. After considering the rival contentions of the parties and upon perusal of the materials on record, it is true that nothing is there on record before this court today to come to a definite conclusion that provisions under the Gazette notification or SOP has been invoked by the state. Though the state has submitted that in exercise of the provisions thereunder, tea estate was allowed to be taken over by respondent number 7. There is nothing on record to show that the petitioner is not in possession of the tea estate or the private respondent has taken over possession. It is also a fact that the jurisdictional additional labor commissioner has not yet commenced conciliation proceeding. Pray be to the writ is there, praying for an early disposal of conciliation. In view of the above, the court is of the view that this writ petition is required to be adjudicated upon affidavits. The state must disclose in its affidavit whether provisions under Gazette notification and SOP have been invoked by the state by issuing any written notice or communication served on the petitioner. State shall also disclose the entire and detailed dues of the workers at the tea estate payable to the workers in accordance with law as on January 17, 2025. The state shall also disclose what is the actual amount paid by the respondent number 7 on and from January 17 till today.
You nikalo, SOP nikalo.
The Respondent number 7 shall also disclose through its affidavit the details of payment it has made, showing proper evidence of payment and to whom. Respondent shall file detailed affidavit, so and so affidavit. Then, my lord, there's an interim order in my favor. There shall be no further steps in the meantime in the matter. My lord, no problem. However, since the interest and livelihood of the laborers who have put in their blood and toil for the garden are of primary importance, on and from January 17, 2025, entire dues of the laborers and workers at the tea garden in every respect to which they are entitled to, in accordance with law, shall be deposited. My lord, I have a grievance here, not with regard to me depositing, by the petitioner and respondent number 7, independently with Office of Jurisdictional District Magistrate, who shall open a separate bank account with any, keep the deposit so and so. Such deposit shall have to be made by both parties positively within 3rd of each calendar month, commencing from 3rd. Office of Jurisdictional District Magistrate shall regularly disburse payment to in every respect to which they are entitled in accordance with law, payable on and from 17, and every succeeding month regularly and continuously till disposal of the rate. It is made clear that such deposit to be made by petitioner and 7 shall not create any right of equity in either of their favor. After affidavits, further decision, so and so. Fate of deposit shall abide by the result. Now, my lord, I have 2 grievances, my lord, apropos this order. My lord, respondent number 7, who is a rank outsider, my lord, during the subsistence of my lease, my lord, cannot have, my lord, any locus in the matter. My lord, all that has happened, my lord, I want to show your lordship the MOU, my lord, which was, my lord, given to us on...
Before you proceed to the MOU, have you been informed by the state with regard to the outstanding dues of the workers?
No. But my lord, we have put in, my lord, we have put in after, my lord, the mentioning done before your lordship, my lord, 21 lakhs. My lord, that was our calculation.
One
my lord,
second, Mr. Additional Advocate General, what is the outstanding due?
My lord, before your lordship's query, whether we have intimated or not, my lord, may I hand over the...
What is the outstanding due?
My lord, the wages from July 2024.
Up to 17th of January 2025, what are the outstanding dues of the workmen?
My lord, that I am saying, my lord, it is due from July 2024.
What is the outstanding due of the workmen? Quantum.
Quantum, my lord, then my lord, I just need a
your officer, your department was directed to communicate by 17th of January.
My lord, what I have done, my lord, allow me to.
Again, tell us the quantum.
My lord, the PF due is, my lord, 1.4 crores.
1.4 crores.
PF due till due from February 2023 to July 2024.
And other
gratuity due is, my lord, 1.7.
Please supply a chart of the dues.
Yes.
To Mr. Mukherjee's advocate on record.
Yes.
Mr. Mukherjee, we'll take
Yes,
it up tomorrow.
Lordship.
Very well.
What we propose to do is,
yes,
we understand your grievance with regard to the purported involvement of 7th respondent. In the event you cover the dues, we would protect your interest under the subsisting lease. Right? So first and foremost, your client must know what is the liability. In all probability, you already know. But nonetheless, in terms of this order, the state shall intimate your advocate on record with regard to the dues. And you undertake to pay this amount in the manner by which you propose by tomorrow.
Yes, ma'am.
We will already deposited. We take on record. We already deposited 21 lakhs.
Yes, ma'am. And my lord, not.
Yes,
my lord. Tomorrow, my lord, once this is indicated, my lord, my lord, should be able to, my lord, at least tell your lordships, my lord, whether we agree to this, the figures which are mentioned, and my lord, with regard to, my lord, our rights, my lord, also need to be protected in, my lord, one other fashion.
Yes, tell us.
My lord, one is, my lord, if a lockout is declared, now, my lord, from the date, there's no challenge to the lockout. My lord, unless, my lord, it is, my lord, established that the lockout was illegal, my lord, there is no liability to pay. But my lord, I will, my lord.
The
still, my lord,
liability, Mr. Mukherjee, is to pay with regard to the prior dues.
yes,
When
absolutely.
when your lockout is declared, the payment of wages may be subject matter of decision of the lockout.
Correct.
But till the date of the incident,
I'm grateful, my lord. I'm grateful. That's
let
all
us
that I
see
need.
what is the outstanding dues.
Correct, correct.
There
My lord,
was no lockout. There
We
was
know
a
there is no,
suspension.
we are conscious that there is no lockout.
Yes, madam.
All right.
Yes, madam.
So we will not maintain any observation on lockout. But what we would propose to do, Mr. Additional Advocate General, is the requirement of, or rather the bona fides of the appellant who has come up against a discretionary order to show his bona fides, the outstanding liabilities of the tea garden must be liquidated.
As below, the outstanding dues and liabilities have
Mr.
not been paid.
Additional Advocate General, we would have appreciated if you had been able to indicate to us here and now the communication of the liabilities to the appellant. You were supposed to do it.
Kindly see the documents.
Yes, you were supposed to do it by the
Kindly see the
17th of
1st April 2024, my lord. Kindly have a look, my lord, what I said. Kindly see, my lord.
Yes, what is this? Issue related to payment of wages and
Wages and others, my lord.
So
we have asked them to make payment and come in.
Sir, give us the quantum.
My lord, they are, my lord, definitely. They are, my lord.
Are you aware of the direction of this court, which is under challenge?
Yes,
You have not challenged it, right?
No.
Neither have you or the seventh respondent.
Yes.
Now, you were specifically said that state shall disclose the entire and detailed dues of workers
Yes, my lord.
payable to the workers in accordance with law as on 17th January.
Yes, Lord.
Disclose it.
Lordship, tomorrow. Tomorrow. Or give me, Lordship, half an hour time, Lordship, I will disclose, my lord. Because PFI said, my
So
lord.
today we are not on 17th of January. Why would you take half an hour?
My
You
lord,
are answering an appeal on 28th of January,
my lord, this is the-
when you were required as per the order impugned
My lord, when
to
the-
disclose the outstanding
my lord,
liabilities.
when there was an order, my lord, it was the order of the my lord on Friday.
Yes, so
It was on Friday, my lord.
so
my lord, they have time
After,
till
my
the
lord,
5th.
it has been
My lord, they
served.
have time
My lord,
till the
yesterday
5th.
we
evening, my
want,
lord,
all right, Mr. Chaudhary,
My lord.
you communicate in the course of the day
Lordship.
the outstanding liabilities to Mr. Mukherjee's adequate
Lordship.
record.
Lordship.
All right, Mr. Mukherjee, and
Yes, ma'am.
tomorrow you would disclose to us the manner in which you propose to make the payment.
Yes, my lord. I'm
All
grateful.
Lordship,
Appellant?
Lordships, I beg to appear on behalf of respondent number 7, Lordship.
Very good. In the you have not appealed against this order?
No, my lord.
We
No,
are
my lord.
not touching. You would be happy enough. We would be very happy, sir, if in addition to Mr. Mukherjee's client, you match the same amount as a backup. If Mr. Mukherjee's client provides the liability, we will ensure his continuation, subject to the final result of the writ petition. All right.
My lord.
Heard, the appellant is the lessee of tea garden named and styled as Torsha Tea Garden. An incident occurred in the tea garden which prompted the state respondents to initiate action under a standard operating procedure SOP dated 12th November
6th November, my lord. Gazette notification is, my lord, 6th November.
6th November
My lord, that is
2020.
disputed. My lord, there's nothing, my lord, on record. That's completely
All right,
disputed.
we have never said a gazette notification. We have said that a standard operating
No,
procedure.
no, no, no. My lord, they have not, my lord, initiated any proceeding. This was the oral submission made. My lord, there's no sanction in law. There's no sanction.
No, that কি বলে,
The learned judge has also observed that.
yes, we have seen that. We have seen that. Now, initiate action against the appellant lessee. Seventh respondent was directed. What was the seventh respondent called upon to do? Take over management.
Yes, to run and operate.
Acha, seventh respondent was
By a
entrusted.
bipartite agreement.
All right, was entrusted to carry on the management of the tea estate. Full stop.
Milord, may I interrupt, Milord, for a moment, Milord?
Mr.
Milord, there was no entrustment. There's a bilateral between workers' union and them.
Right, right.
Milord, nothing, no entrustment.
By a bilateral arrangement between the workers and seven respondent, the latter was permitted to carry on the management of the tea estate.
In terms of Milord SOP.
Tea estate. This prompted the appellant to approach this court inter alia, praying for directions for inter alia to protect his right as a lessee under the subsisting lease. After hearing the parties, Honorable Single Judge by the impugned order inter alia held that appellant was still in possession of the tea estate and directed no further steps to be taken.
But it was not the observation. It was not on the record whether appellant is in the position or the respondent number 7 has taken over the position. That was
My lord, may I be permitted to submit, my lord?
Yes.
As per the MOU dated, my lord, 17th of January, my lord, that MOU was entered between, my lord, Rangopur Tea Estate Limited, my lord, which I am representing, my lord. I have wrongly been implicated in my personal capacity. This is not the case, my lord. I am representing Rangopur Tea Estate Associations Limited, who has taken over the management, my lord, and presently we are in possession of the tea estate, my lord.
All right. Inter alia held that there is nothing on record to show that the appellant is not in possession or that the private seventh respondent is in possession of the tea estate. However, observing as such, Honorable Judge directed no further steps to be taken in the matter. State was directed to calculate the amount due and payable to the workmen of the tea estate as on 17th of January 2025 and 25, and the appellant as well as the seventh respondent were independently directed to deposit the outstanding dues with the office of the jurisdictional district magistrate, full stop. The parties were also directed to go on making such deposit with regard to workmen dues within 3rd of every calendar month, commencing from 3rd February 2025. During Mr. Mukherjee submits that his client has already put in a sum of rupees 12 lakhs.
21 lakhs.
21 lakhs in discharge of workmen liabilities, towards outstanding dues payable to workmen.
My lord, the exact
Of
figure
Mr.
is, my lord,
Mukherjee. Milord, we are carrying the draft in the name of the district magistrate as directed by the honorable court. It is not yet put in. We are carrying
He
the draft.
has already prepared a bank draft to the tune of 21 lakhs.
99,000.
99,900.
99,000 so and so in discharge of outstanding liabilities towards workmen. Mr. Chaudhuri, Additional Advocate General, contends that the outstanding dues are much more and much more. In fact, the outstanding Provident Fund dues run to around rupees 1.4 crores.
Gratuity 1.7.
He see, in such view of the matter, we direct Mr. Chaudhuri to communicate to the advocate on record of the appellant as well as the seventh respondent the amount, the total amount of outstanding dues of the workmen as on 7th January 2025. Full stop. Appellant shall propose the manner in which the appellant and the 25 in the course of the day.
Till 17th January.
Till 17th.
My lord, may I just indicate one thing with permission of my lord?
Yes,
my lord,
Mr.
after taking of the management of the tea estate, my lord, so far we have paid 14,12,707, my lord, the exact figure, my lord. Around 6 lakhs, around 12 lakhs toward wages of the laborers of the garden and other correlated expenses, my lord. So far,
you have paid around 14 lakhs, right?
14 lakh 12,707, exact figure. my lord.
Mr. Mukherjee, on the other hand, seventh respondent contends that they have paid an amount, they have paid around 14 lakh,
14 lakh
towards workmen wages. Full stop. তারপরে বলো on Mr. Chaudhary. Copy, full stop. Appellant shall take steps to liquidate the said dues. On the appellant shall disclose the manner in which they propose to liquidate the outstanding dues. Full stop. Outstanding dues. Matter will appear tomorrow.
Grateful, my lord.
My lord, kindly, my lord, give us this indulgence. My lord, after verifying, my lord, the figures which are given, my lord, by this.
The Provident Fund figures are not to be verifiable. 1.4 crores must immediately come in.
And this is the
Otherwise, Mr. Mukherjee, we make it clear we will direct Provident Fund Commissioner to initiate prosecution against your client.
My lord, Provident Fund, my lord, the lordship's absolutely right. My lord, if it is actually
There are
due,
certain areas, statutory dues. Provident Fund is a statutory due, Mr. Mukherjee, must be cleared.
no, whatever is the correct amount.
Correct.
if-
Whatever is the correct amount, as of now, if you pay 1.4 crores, it won't be very much beyond the correct amount, we presume. You come up with any amount, you show us the payment that you have made, but by tomorrow you come up with a proposal, how you propose to pay it.
Grateful, my lord.
Grateful, my lords. With the leave, my lords. Grateful.
पैसा तो बड़ी बात है। Provident Fund नहीं देगा तो prosecution नहीं कर सकते। Dismiss करेगा, prosecution नहीं देगा। Yes.
Well, this is a first appeal. Well, I am for the appeal in plaintiff. The first time paper was ready, my lord. In the meantime, they filed an application of additional evidence by the defendant. Because I have raised the question maintainability. I just filed the affidavit, my lord, on this. And that will matter we have.
Have to be in opposition to can so and so within 1 week.
And the matter that will file.
Reply 1 week thereafter.
That will heard first, then the appeal will be heard. Yours kindly.
Generally, Order 41, Rule 27 is always heard with the appeal.
He's my lord, not maintainability. So I raise the question. So my lord, it will heard first, then my lord.
We have never said anything. We have just said in the can, You file your affidavit. You raise the issue of maintainability in the opposition.
I reserve, yours is absolutely, because usually additional evidence is filed by the appellant. Here the defendant has filed, my lord.
Defendant is also entitled to
Yes,
file.
both parties. Law is
Order
that both,
41, Rule 27 is
both
not
parties.
appellant
Both-
specific.
Both
Party
parties,
specific.
both parties, my lord. And that is,
Can three.
I say usually filed.
Yes.
I'll file.
Next.
31. Actually, I'm praying for next.
Next circuit.
Lordship, item number 32, kindly bring for next circuit, Lordship.
Same.
Grateful, Your Lordship.
Nobody appears. Adjourn for the day. Which one? 30. Yes, 34.
We have come up in this High Court against the order of ad interim injunction, Lordship. Your Lordship kindly takes my stay application.
Where is the impugned order?
Yes, it is at page 96.
This is a partition suit.
It is no, I have claimed my 1/7 share. They have transgressed the share and my property and started making construction of the building.
It will abide by the result of the suit. What is it's a partition suit? What if they're making construction that is subject to the result of the suit?
Sorry.
Any amount put into the hotspot is divided as per your share. So how are you prejudiced?
Lordship, I bow down what is followed.
You understand what we're saying?
Yes,
Until and unless your possession is disturbed or you are thrown out of possession, and that is what the honorable learned judge holds, that there's nothing to show that you are in possession of the suit property.
Lordship, subject
So
to
if there is a development in the suit property, it is good for you.
Yes.
The value of the property grows. And 1/7 share also will grow. Correct?
No.
So what is the, there is nothing. The issue will be decided on exchange of affidavits before the single judge.
Before the single judge, but
Sorry, before the trials court.
before the trial court, till then,
Till then, nothing.
No, till then, at least not to proceed with the construction. Not to
No,
proceed.
sir, sorry. Why? You are not in possession?
Lordship, the law says that the possession
Why,
of the
how
owner
you
is the
are
possession of the
aggrieved,
all.
how you are aggrieved if the construction takes place? Tell us.
Now, Lordship, everyone is having 1/7 share.
Huh?
Now, I don't want the construction to happen on my share. It's a undemarcated, undivided property, Lordship.
And your consent has been, then you have to file a separate application against the, have you, in this suit, how will you get it? The developer is not a party to the suit, you have to file.
He is a
separate-
party to the suit. He's a party to the suit. If your Lordship kindly takes page number 80, which is the my plaint, respondent number 7, Ochinto Shah, he is the developer. Now the respondent defendant number 1, Ubhijit Nondi, and in collusion with the respondent number 7, they have started making construction.
Have you given, you give notice?
I have served notice. I have served notice. I have served notice. My affidavit serves. And even my judgment that they're raising the construction without the building plan. They cannot get a building plan.
What is the gift deed?
Yes. You get this at page. They have transferred the other co-sharers share into the share of the respondent number 1.
Then?
They have challenged the gift it also.
That you challenge. So defendant number 2 transferred it to defendant.
Yes, defendant number 1. And they are claiming that they are the only legal heirs. They are the only owners of the property.
And you are claiming as?
I am also the owner. I am also the son of
Shefali.
Shefali.
Who is appearing? Can you give notice again?
I shall then serve. I don't know who is appearing, but I shall have to serve again on the parties.
So nobody has entered appearance in the trial court.
What I have heard, instructed from my learned colleague in the court below, only 2 of them have. Out of 7, only 2 of them have.
All right, then serve application.
Gotcha. I shall serve again.
Appellate service filed, nobody appears for respondent, fresh notice be issued upon the respondents. And affidavit of service be filed on the adjourned date. 1 week, 2 weeks,
Lordship.
2 weeks.
Lordship, 2 weeks, but in the meantime, some protection. Lordship.
What protection?
Look, they are going on carrying with the protection. They are carrying on with the protection, at least some protection.
Let us see, let them come here.
Lordship, some protection.
We will,
For
we have
two-
followed your submission, but we want to hear them and then pass.
But I've already served them, they are not appearing, Lordship. They are not appearing, that's the difficulty. If they continue with the construction.
Appellant contends to be the owner of the property.
Lordship.
He submits that the first respondent had entered into a development agreement to undertake construction, a development agreement with the seventh respondent to undertake construction on the suit property. The suit property, appellant is not a party to the development agreement. Appellant, though a co-owner, is not a party to the development agreement. Trial judge failed to consider this aspect of the failed to consider this aspect while declining to injunct the while declining a prayer for ad interim injunction. It is also ad interim injunction. Interim injunction, good stuff. Fresh notice be served upon the respondents. Matter where affidavit service be filed. Matter will appear 2 weeks hence. There shall be an order of status quo with regard to construction made on the property in terms of the development agreement for a period of 3 weeks or until further orders, whichever is urged.
I shall serve them today. Grateful, Lordship.
Yes. 35, I am for the appellant, my lord. And the appellant before your lordship is the plaintiff in a suit for declaration, partition and injunction, my lord. My lord, my prayer for ad interim injunction has been refused, against which I have preferred this appeal, my lord. Now, I am a co-owner of the property, my lord. If you should kindly seize the order, which is at page 66 of my injunction application.
So you bought from Pushpendra and
Pushpendra.
they bought from
They from the another co-owner whose name is Jagadish Chandra Roy.
What is the nature of encroachment that you?
Well, he is making construction, my lord, over the plot.
Where is that? There is
My lord, yes,
nothing.
my lord. My injunction application is at page 60, my lord.
That will be, the judge says that there is no document proof to show that there is encroachment on your share.
My lord, the observation was that. My lord, but at present, the defendants are disturbing the share of the plaintiff and trying to encroach her land. However, on perusal of the document
Yes.
filed by the plaintiff, it appears that the complete chain of deed is not in order as referred to in the plain. Then all original documents have not been filed. My lord, if you also kindly sees, the page 20 is the record of right of Pushpendra, my lord. And page 22 is the record of right of Jagadish Chandra Rai. My lord, the Khotian numbers are
Correct. Even if, let us say, you had made out a case of the chain deeds being placed. Just by a bold aversion that he is trying to encroach. He had interim order.
Is that matter, he is making construction over my property, my lord.
Yes, so where is the material to show that they making construction? You place let the ad interim, the interim injunction application be heard out quickly. Will give a direction. The
He's carrying on construction, my lord. This is a difficult.
judgment and order.
Almost the building is at the verge of completion, my lord.
Judgment and order dated order dated 13/11/2024, declining ad interim injunction in a partition suit has been, as said, appellant is the plaintiff who claims that he purchased share in the property from one Pushpendra Dev Kongar, while the defendant had purchased his share from one Jagadish Chandra Rai. Appellant in the plaint, the appellant contended that the defendant where is your plaint?
Plaint is at page 14, my lord. 14. I purchased it from Pushpendra's son.
Jitendra Dev.
Suro Jitendra.
Suro Jitendra.
From his son, my lord. Pushpendra's son.
Appellant is না এইভাবে করো এর আগে দাও, one Pushpendra Dev Konar was the owner of 3 decimals of land out of a total area of 5 decimals in RS plot number 33. He died, Pushpendra died in intestate, leaving behind Pushpendra died intestate, leaving behind his son Surojitendra Dev. Appellant claims to have as the sole heir. Appellant claims to have purchased the land from said Appellant claims to have purchased 2.5 decimals of land from the said Surojitendra Dev. Whereas defendant had purchased Jitendra Dev and full stop. In 2023, defendant purchased the land from
Horipoto Saha, who purchased it from Jagadish Chandra Roy.
Horipada Saha, who in turn had purchased the land from one Jagadish Chandra Rai, owner of the remaining 2 decimals of land in the partition. So you have got 2.5, then half decimal is with half decimal is with Jitendra Roy, or
Half decimal is with Shuro.
so have they been made parties in the claim? You cannot have partial partition. 2.5 out of 3 you have purchased 2.5. 2 has gone to defendant. What about the half decimal of land? They are not plaintiff. Then
He has not.
how can the suit is not maintainable? Defendant, কি বলেন জানো? Owner of the alleging that the defendant was illegally undertaking construction on the land. Appellant had instituted the suit for partition. His prayer for ad interim injunction was turned down by the learned judge, inter alia observing that the complete chain deeds as referred in the plaint had not been submitted, had not been filed. There was no document in support of the plea that the appellant's possession is being disturbed by the defendant. Learned counsel contends that the requisite contends that the records of rights were placed before the trial court, and there are were placed before the trial court, there are materials to relevant materials to show that his possession was being illegally disturbed by the defendant was ignored. We have considered the materials on record in light of the aforesaid submission made on behalf of the appellant. Appellant claims to be owner of 2.5 decimals out of 5 decimals of land in RS plot number 33. In the plaintiff, He-
Defendant number two's name is also recorded as a co-sharer of the Chut property. But there is no detailed description with regard to that 0.5.
Then there is
There is no-
nothing. It should be, as
No,
per your plaintiff
no.
case, it should be. Let that issue be decided. We are keeping all the issues open. It is the plaintiff's case that defendant purchased purchased 2 decimal of land from in the said property from one Hori Podo Saha, who in turn had purchased it from Jagadish Chandra Rai. Bold allegations were made, bold allegations have been made in the plaint that defendant is seeking to disturb the appellant's possession. Noticing the lack of contemporaneous documents in support of such plea, the trial judge declined prayer for ad interim injunction. We do not find any illegality in the said order. It shall be open to the appellant said order. Accordingly, the appeal is dismissed, observing that the requesting the trial court to dispose of the injunction application at the earliest, after giving opportunity of hearing to both the parties. All issues are kept open. There may be some amendment you may see in the plaint.
And if line may be added, that the trial court will not be swayed by this.
We have just said, we have kept all issues open. All issues are kept open. No. 3 decimal. 5 decimal. 2.5, 5 করেছে আর ও 2 decimal জগদীশ চন্দ্র রায়।
Grateful, Lord.
Yes, petition judge Next.
Well, 36, my lord, I am for the appellate, my lord.
Yes.
My lord, my lord, in the probate proceeding, my lord, ex parte probate was allowed, my lord. It is on 2020, my lord. Thereafter, my lord, I came to know regarding that on 2022. My lord, I filed an application under Order 9, Rule 13, along with that, my lord, application for continuation of delay. It was delay of 591 days, my lord. My lord, the learned judge, my lord, has rejected that application, my lord. Consequently, my lord,
Give notice to the respondent.
my lord, in the meantime, my lord, no property may not be
Oh,
alienated.
sorry, no, not at all.
My lord, kindly, my lord.
Notice. Respondents.
In the meantime, no transfer, my lord, no third party.
Why? Not at all.
My lord, it's a probate proceeding, my lord. My father says.
Application can be served upon respondents to register speed post with acknowledgement due. After service file, matter will appear for weeks.
Get.
Yes.
This act is I'm very scared of this act, income tax. My lord, the matter in appeal is an order passed by the appellate tribunal in Kolkata. The facts that attend the case, my lord, is a person's accounts were assessed by the income tax authority.
Against which order have you challenged? There are two orders which are,
Lordship,
that is 23/11/23 order.
yes, my lord. So there are two assessment years, 2012 and 2013, and 2013 and 2014. We have challenged the 2012 to 2013.
Not 13/14.
No, my lord.
The Supreme Court is covered by this judgment, the covered decision. Why should we reopen it? The reopening question was set aside. Come to paragraph 8.
Lordship,
Read paragraph 8. Covered decision.
on the second plea that the approval has been granted in intimation used and without.
Second paragraph 8. There are two paragraphs.
The undisputed facts are that the assessment in the instant assessment year was framed under section 143 subsection 4 of the Act. And the issue of the unsecured loan was specifically asked by the AO and replied to by the SSC with all evidences as filed by written submission. The AO discussed these loans in the assessment order and thereafter made a disallowance of interest of rupees 8,36,368. In the assessment framed under section 143.3 of the Act. Therefore, the SSC had furnished all evidences qua the said loan before the AO in original assessment proceedings, and thus the SSC had disclosed all the information qua the loan. I consider the factual matrix of the case. In our considered opinion, the reopening has not been made in terms of the first proviso of 147 of the Act, and therefore cannot be sustained. The case of the SSC is squarely covered by the decision of Honorable Apex Court in the case of Seattle Limited Supra, wherein has held under the petitioner is impugned the notice dated March 27, 2019, issued under section 148 of the Income Tax Act for assessment year 2012-13 and the order dated 31 March 2019 rejecting the petition objection.
Now come to page 7.
Lordship.
For reopening, having gone through the beyond further.
Last portion is relates to 12, 13 and 14. Accordingly, we are inclined to quash the reopening of assessment. This is up to this.
Correct. So just read the paragraph before that.
In the facts and the instance case are materially same as that of the decision taken by the Honorable Apex Court in the above decision.
There is no suppression of material fact.
My lord, in this case, what happened, my lord? Opening of reassessment or reassessment of escape income comes in various ways. My lord, in this case, a third company was being raided by the income tax authorities, and while raiding that company, information was disseminated that that company had given loans to this this person. That needed to be verified. And this was discovered by the department in the year 2019. And her account was assessed in the year 2012-13.
Come to paragraph 7.
My lord.
Which paragraph 7?
Paragraph 7 of the order. After hearing the rival contentions. After hearing the rival contentions and perusing the material available on record, we find that the assessment has been reopened on the ground that the assessee is the beneficiary of accommodation entry by way of unsecured loan of rupees 25 lakh. The said fact came into the light during the survey conducted on Mr. Anil Kumar Khempa and companies operated and controlled by him. Accordingly, notice under section 148 was issued on 13/31/2019. And Swapnagar's account was assessed in 2012-2013. Subsequent to her assessment, Khemka company was raided and this information was available in 2019. So the appellate tribunal's reasoning that this was available with you when you assessed her account.
Let us read further.
My lord, we know that even in the original assessment proceeding, this issue had been examined by the AO when the assessee furnished the details of unsecured loan and interest thereon, and the AO extracted the details of unsecured loans and interest in page 2, para 2, page 4, and thereafter considering all contentions and arguments of the assessee, a net disallowance of interest was made amounting to rupees 8,36,368. But my lord, this account was not there.
The fact that the loan had been given by Anil Kumar Khemka and company was already disclosed by the assessee and taken into consideration. Okay?
My lord, there are several entities found in Anil Kumar Khemka, not one.
That is not a part of the inquiry here.
This inquiry was not available in 12 and 13. That is our say.
Your loan, what the unsecured loan of 25 lakhs, Anil Kumar Khemka, there was a disclosure that it was a loan from Anil Kumar Khemka, and you disallowed the interest on the loan.
My lord,
what more?
While when Anil Kumar Khemka's company was raided, it was found out that the loan is bogus.
Okay.
The loan is bogus.
Yeah, the bogus. That's
So
why,
that assessment is faulty, my lord.
that is why you disallowed the interest. That is why you have disallowed the interest. Why should again it person be vexed from that?
My lord, my lord, 25 lakhs will be treated as an income.
8,36,000 interest was disallowed. That he has paid interest on that loan.
Yes, my lord, but now it will be computed as an income.
That is exactly what it has been, sir.
No.
When the assessing officer disallows interest on a loan, that it is not considered as a part of the taxable income. It's already done. Why should again it be brought into notice that Khemka, there were other loans also?
My lord, that now it is a taxable income, my lord. That 25 lakhs loan was never there. It is her money. Because she showed that I have given 25 lakhs loan to Khemka and company, which is totally false. But when the investigation wing on 29/3/2019 gave us the information that this entry of 25 lakhs is bogus, then only the notice was issued. My lord, if I may,
There is a point here, as a fee. But the investigation report was given. That it was really known by just saying that there was no proper verification. Hold on a second, is on the investigation report only on the. As I see, and if the investigation reveals that there was dishonest material that. This is 5 years. This was in 2019. And 4 years with the permission. Can you give us the income tax act with regard to 147 and 148?
notice.
The your earlier, the order, Mr. Singhania, would you file the order 23/11/23 of CIT appeals? Why not?
Can we file it?
Lordship,
I will file if your lordship started.
But you should file it.
No, we have to, actually, my lord, our appeal was directed to the appellate tribunal's order.
Correct, but you should
We
have.
will also annex the
the
CIT
orders,
order.
na?
Can your
We'll
lordship
arrow.
file all the documents?
The orders should be there.
Lordship. এখানে আছে।
What we are, what.
If
and
my lord wants to peruse, we have it.
Let us see them.
Yes, বার করে দিন।
We take it up 2 p.m.
Lordship.
Make 2 copies of those orders.
Lordship.
And bring the income tax act.
Lordship.
We have followed, Mr. Mujumdar, your submission that there was an investigation done and the investigation revealed certain facts. Whether that will be sufficient in light of the proviso to in under 148. The opening was under 148.
48.
So you satisfy us how it will come within 148. Because with regard to the investigation aspect, the first paragraph 8, the appellate tribunal says that it was done in haste. No proper verification was done. This we feel requires to be examined. If there is material, then whether haste or lack of haste will not be a question of jurisdiction. And that is why we want how the CIT appeal dealt with this issue.
Lordship. We'll come back as to my lord.
You will go home.
Item 41.
Your 41 will not be taken up. How will you know that others will be interested or not? Huh?
You want to say from 40 to the 3.
Let it be called. It will be called shortly. Wait. Call the list. কোথায় গেল? Where is Mr. Mujumdar?
Unmuted the muted মধ্যে ডাকতে এবার আমার নেক্সট
মিউট করতে হবে?
মিউট হলো
না, মিউট খুললাম।
But why? What happened, Singanya? এই অ্যাক্ট গুলো তো
My lord, sorry, I came a little late.
Oh, yes, all.
My lord, the orders we have collected.
All.
Income tax. 147.
No, 137. আসো এটা এটা সিসি এরিয়া আছে না এখানে 133 তে ওরা প্রসিডিং করে ইনফরমেশন পেলে 2019 ওদের ওখানে
So according to you, your exercise of power was under 148 A clause C. 148 will not apply. Any information?
Well, actually, it is under 147. We received the information.
147 gives you the power to assess what has escaped the
Escaped.
assessment.
And then when the
Now, what has escaped the assessment, you have to do in terms of 48, capital A.
Lordship.
And that is after giving an opportunity of hearing. Here, there was no opportunity of hearing given. because the requirement of clause C, that in the course of a search under 132, information transpired.
Yes, madam.
Let us see how CIT appeal has dealt with this issue. And the Supreme Court decision which the A dealt with.
CIT appeal. Appellate tribunal.
Tribunal, how it is distinguishable.
Appeal court, appellate tribunal.
One 148 notice, 148 capital A notice. 148 to reassessment notice. So this was not on the same material, on materials collected during investigation. All right. The appeal shall be is admitted on the following grounds. For that, whether the tribunal erred in law to come to a finding that the reassessment under section 148 of the Income Tax Act had been done on the basis of same facts, on the basis of same facts, whether the additional material, what was the additional material? Statements.
No, my lord, it was an search done by
A search, what material came out of the search?
that certain sham transaction was made by the
That's
company.
very key. What was the additional material in the course of the search? Statement of Kenbaka.
Statement of Kenbaka.
Whether the additional materials collected in the case, collected in the course of search under 132 of income tax income tax of the Income Tax Act would constitute whether the would justify the reopening of the would justify reopening or would justify reassessment of escaped income under section 147 of the Income Tax Act, whether the tribunal was right in observing whether the tribunal was right in observing that the approval granted by PCIT Siliguri was illegal and without application of mind in the facts of the case. Whether the tribunal erred in law in applying the ratio in CEAT Limited, CEAT Limited, ACIT versus CEAT Limited in the facts of the case. Paper books be prepared within 4 weeks.
Yes,
All right,
Madam.
these are the grounds.
My lord, this will remain before the DBO.
Division bench.
Huh?
It will be heard by a division bench.
Should we?
That is just,
It doesn't require, the rules say it.
Yes, ma'am.
Why should we say that it should be heard by a division bench?
SAT though.
But so we have filed a SAT.
Actually, my lord, we had filed SAT, but the stamp reporter said it will be FAT.
All right, if whatever is the number, put in the paper books. Paper books be filed within 4 weeks. Issue notice, paper books be filed within. Andhra Pradesh. थोड़ा बहुत Yes, next month. হাইকোর্টে কি নম্বর হয়? ভাই হাইকোর্টে কি নম্বর হয়? প্রিন্সিপাল বেঞ্চে একটু জেনে নাও। হ্যাঁ, ফোন করো। হ্যাঁ, তোমার ওখানে ম্যান্ডামাস সার্কুলে এগুলি অরিজিনাল সাইটে হয় 260A অ্যাপিল। কি নাম্বারিং করে ওরা? হ্যাঁ, সেইভাবে নাম্বারিং। Next.
My Lordship, I'm here for the petitioner led by Ibrahim Sheikh. He's in VC.
Yes, very good.
The tribunal,
30.
my lord,
38.
38,
I don't know, 38.
38.
My
Yes,
lord.
Mr. Sheikh, Ibrahim
my
Sheikh.
lord, my lord. This is challenged by the order of the tribunal, wherein with non-application of mind, kindly see the impugned order, page 64, in the, my lord, page 64 of the impugned order. 64. It is a Dajin Harness candidate case, page 64. The applicant has approached this tribunal by taking advantage of the order passed by the Director of Homopathy Government of West Bengal, dated 12/2014, to the writ application. We have already observed that the Director of Homopathy Government of West Bengal, the order perused, which he was misled for non-disclosure of the fact of rejection earlier application for compassionate appointment of the another brother applicant. We would also like to point out that the director of homeopathy government of West Bengal has not been implicated as a party to the present case. As such, he is not in a position to put forward his view before tribunal. But in this matter, but the director of homeopathy government might kindly see he is a respondent number 3 of the application, original application. He is a respondent number 3. The learned tribunal non-application might recorded that he is not a party to the proceeding. Page 26, page 26 in the original application, he is a party to the proceeding. Director of homeopathy.
When the erstwhile employee expired?
But it in 2004.
In 2004. When did you
Madam.
apply?
My lord, kindly see then page, my lord, 53. Page 53 of the application. 53.
His rejection of application for compulsory.
My lord, kindly see.
Earlier, applied and rejected. Now we have
My lord. Page 53, kindly see. The understanding is to refer the prayer dated 18th December 2030 addressed to the President of India to the state. Her earlier prayer for employment of her younger son was rejected by the authority on technical ground. While considered the prayer of employment of his son Sandeep Nandi on compassionate grounds, the Honorable Tribunal in its order dated 29/4/2010 in OA number Ato, Sandeep Nandi versus State, observed the applicant father having expired on 1st July 2004. The alleged immediate need assistance cannot be said to exist still now after a long lapse of more than 5 years. In view, the application is not maintainable and sustainable and dismissed. Hence, the understanding rejected the liability. Next, my lord, page 54. Page 54. This is the letter of the Director of Homeopathy. This understanding is referred to the subject captioned above, that in terms of memo number 2, a 3-man inquiry committee was considered by him to inquire into the case of Milan Kanti Nandi, ex-compounder cum dresses of MGN Hospital, Coach Bihar, in the perspective of the application for appointment of compassionate ground of his son Sandeep Nandi. But it appears that the said inquiry was not carried out, as an inquiry has already been done as per Somen Nandi, younger son of the Milan Kanti. Now, the understanding is request him to constitute a 3-man committee under him and to make a fresh inquiry into the claim of Sandeep Nandi. Now it is, my lord, again a fresh inquiry was done, my fresh inquiry. Sandeep Nandi as a submit report earlier. This order, my lord, on 12 December 2014. My lord, can you see the next page? In 21st May 2015, the director who...
Mr. Sheikh,
My
Ibrahim
lord.
Sheikh.
My lord.
We will set aside the cost imposed on your client.
My lord.
You withdraw the appeal.
Well, it is a very, my lord, unfortunate candidate, my lord.
Very unfortunate candidate, but public employment is not a heritable asset. That someone
is it-
doesn't get it, you will get it.
Is a presidential order, my lord. President, my lord, pass the
You go
order.
to president, we are dismissing your application, carry it to the president.
As your lordship.
Yes. Applicant, you are father, your son.
Son, my lord.
Ah.
Elder son. Sandeep Nandi.
One of the sons of one Milan Kanti Nandi.
Died.
Walking, who was employed as compounder cum dresser in
My lord.
MGN Hospital, Coach Bihar, died on 1st July 2004 while in service.
Well.
After a lapse of 5 years, one of his sons applied for compassionate appointment. The matter was, his prayer was rejected. The matter was agitated before the tribunal in OA 1213 of 2009 and was rejected with a order dated 29th April 2010. Petitioner is another son of the said deceased employee. He took his chance in 2010 and being rebuffed, filed the present application, filed an original application before the tribunal seeking compassionate appointment. Right to compassionate appointment, compassionate appointment is not a public post is not an heritable asset. Compassionate appointment is an exception to appointment to public post through or open competition. It is a privilege. It is a privilege extended to extended to the unfortunate dependents of the deceased / incapacitated employee to tide over unforeseen circumstances. Accordingly, such privilege is required to be availed under the terms of the scheme and at the earliest opportunity. The deceased employee had expired in 2004. After a lapse of 5.5 years, one of his sons prayed for compassionate appointment, which was turned down by the tribunal in OA 1213 of 2009. The said order was not challenged, but the writ petitioner, who is another son, again approached for similar relief. The tribunal rightly turned down his prayer. The respondent authorities rightly turned down his prayer on the ground that repeated applications are not entertainable at the behest of the heirs of a deceased employee. It is also relevant to note that the live link between the unfortunate incident between the death of the employee and the application and the prayer for compassionate appointment had already snapped by lapse of more than 5.5 years. Accordingly, we are of the opinion that accordingly, while setting aside the costs imposed on the writ petitioner, we do not find any merit in the writ petition and the same is discussed.
Yes, Your Lordship.
Should bring for next again.
It is so bad.
Lordship, actually, shifting of
Shifting of
our chamber due to shifting
of your chamber.
See, the brief is missing. That's
Same compassionate appointment. Mr. Mohindar.
I was thinking, my God, I get afraid of this bench because they shifted their chamber.
So afraid. There's the last Supreme Court decision that compassionate appointment circulars in the state of West Bengal are all OCOs. They don't apply. Justice Nagratna's judgment. Then with that, how would you apply for compassionate appointment? You are working where?
actually the brief is missing. Kindly.
Brief is missing.
Sure.
All right, next sir.
Get first.
Yes,
I'm for this one.
respondent.
We are the appellant, my lord.
Okay.
Bring for the direction if your lordship allows to file an affidavit.
What affidavit did
in
you?
opposition.
Why? What new facts have been pleaded in the petition? This is against an order passed by the Central Administrative Tribunal. All pleadings are before us. No additional pleading is necessary.
Lordship, we want to file against. the
Against what?
pleadings- Against the pleadings. Lordship.
No, we'll ignore those pleadings.
Lordship,
We will
in order to
ignore those
substantiate-
pleadings. Let us see whether the order is sustainable on the basis of pleadings before the tribunal. These are writs of certiorari. They do not require any additional pleadings
If your lordship, direct-
until and unless a subsequent event is pleaded before us. Is a subsequent event pleaded before us?
Lordship, I've
Then-
been directed, Lordship, I've been directed, to submit to file, if your lordship allowed to file an affidavit in opposition.
No, no.
Let it put it tomorrow.
No,
Yes,
we
yes,
will
yes.
not allow you to file. Acha, Gram Dak Sevak, there is a Supreme Court decision now on Gram Dak Sevaks.
Lordship, the tribunal is applicable, but in this case, your lordship, they prefer the tribunal, then we
All right.
come back to it. There is a series of litigations. sir.
If your lordship
Cut
kindly
time.
allowed to keep it, lordship, on.
We feel no option to set aside the order of termination.
Section 4 or 8.
So why, Mr. Why are you agree with this is the judgment they have relied on, no?
My lord, actually, if I,
Then
my lord, actually, if I am permitted, my lord.
please come to paragraph 20. वही तो बोला है ना सुप्रीम कोर्ट का जजमेंट है इसके ऊपर.
My lord, so far as the question of validity of Rule 8.
हाँ.
My lord, there are two orders of the Central Administrative Tribunal.
Framed, yes.
Actually, see, my lord, actually, this is a, if I am permitted, my lord, this Gram Dak Sevak appointment was made contrary to the procedure.
Maybe.
But when he challenged, first the cat said, you get it done under Section 4. We did it under Section 8. It was given back. He again challenged it. Now
No.
cat says you do it under Section 8.
Second time.
But the termination has not been said, doubted by the tribunal. Only said you do it under this section, you do it under that section.
Restatement for
The termination was made wrongly.
And on the
After
third,
which, lordship, the order was then passed in favor of me, stating that the employment, like, I would have to be installed as far as the service lordship. But yet I have, there is no stay order in respect of the said appeal.
Section 4
Still, I have not get my job.
The impugned order is where is the impugned order page?
27, 6, order 622.
27,
622.
page 81, my lord.
page 81.
81, my lord.
Wow.
अरे दाना होना देखो देखते सीधा देखते तो होना.
Huh. We've seen this order.
এটা রেজিস্ট্রি হ্যাঁ তার আগে আরো দুটো অর্ডার আছে তার আগে দুটো অর্ডার আছে
So he was considered to be in service from the earlier termination. And because he was considered to be in service for earlier termination, he had been in service for a longer period. And therefore, they say that Rule 8 applies.
Not true. Well, first time when he went before the cat said termination has been done under wrong provision.
Correct. Why wrong provision? Which was that order?
First order, my lord. Lordship from page 49 onwards. No, 49 na. 49 na.
The order type continues with 11.
Relevant portion is at page
Mr.
49.
A, you do not require any affidavit to file.
Actually, this matter was been read by Kalyan Sarkar. I've been instructed that a substantial matter could be preferred before the learned court.
We are instructing you that there is no substantial matter before this
My lord,
court.
if I may, what my learned friend wants to say that he wants an accommodation till tomorrow so that senior can come and argue the matter.
That we will keep it day after tomorrow.
Is it that?
Yeah.
Right.
The day after tomorrow, let senior come.
That's it.
All right. In the meantime, Mr. Majumdar, please prepare a list of dates.
Lordship.
When he was initially terminated, because there are 3 litigations. First, there was termination.
Yes, my lord.
Then he went to the
Before the cat.
tribunal set aside the termination. And you had another inquiry and a termination. That termination again was set aside.
No, that was
Secondly,
upheld.
upheld by the tribunal.
That was upheld by the
Then that
tribunal.
goes to High Court.
Then the writ was preferred to the honorable court. Honorable court, in the course of proceeding, put a question to the council of the union. As to
That
the
will the-
constitution, that could not be answered, the matter was remanded back.
To
It
tribunal.
was thereafter taken to the tribunal.
You don't know anything. So now don't butt your nose.
So that matter was remanded back to the London tribunal.
Right.
Tribunal decided that the service is permitted.
Right.
4 and 8.
You just
So, my lord,
give
we
the
will
dates.
prepare a list of dates,
Ah.
right from the initial appointment. That day after tomorrow.
Day after tomorrow.
Grateful.
Yes. Call the criminal appeal. सबका ठीक होता है. The thing is, no, finger के अंदर भी कुछ escape करता है. Because you can provide the mechanism. The smaller minimum. Yes.
41.
Next circuit. Next circuit. Good circuit. Yes. For state, nobody after next survey. Next subject. Last year. Not today. So not today, Correct. Same. 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 Same.
I have for the petition.
Yes. 49, what is there? 1 second. Tell us, what is the case?
Milord, conviction, lifetime conviction, Milord.
Lifetime.
Lifetime. Milord.
Very good.
Milord.
Why lifetime conviction?
Yes, Milord.
What did you do?
Milord, allegation that I killed my wife, Milord.
You killed your wife.
It's allegation.
Who else will kill your wife? It's your wife.
Milord.
Who will be interested in killing her?
Milord, kindly come to annexure. PW2, Milord, page number 18, Milord.
Sure. Sit down. PW2.
Yes, Lord.
Let us see the FIR first.
Yes, Lord.
How your wife died. Yes. So the wife died because of assault at the matrimonial.
Yes, Lord.
This is on 30/10/2008.
Yes, Lord. This is the allegation, Milord.
Very.
The
Now, how many witnesses were examined?
Milord, total
Lacerated.
The total 16 witness examined.
16.
Yes, Lord.
One is the uncle.
Yes, Lord.
Two is the
Local club member, Milord. Well, according to his statement, Milord, conviction made, Milord.
injury. In this case, this is a very nowadays they are giving not in the tabular form, they are giving in serial. Hmm. Who is a local
Yes, my lord.
person?
Club
He
member.
saw the appellant run away and throw a bamboo stick. In cross-examination, you have taken it is unnatural because he did not raise any hue and cry.
Yes, sir.
Good.
Sir, kindly come to PW7, page 27.
PW. Now let us one by one. 3 is the de facto complainant.
Yes, your lordship.
No, 3 is the wife, mother.
Mother of the victim.
And 4 is the brother.
Yes, your lordship. Younger
Huh?
sister, my lord. Younger
Sister,
yes,
sister.
younger sister.
5 is the neighbor. Oh, priest
Yes, your
of the
lordship.
marriage. This is again a neighbor. 7, yes.
Yes, your lordship. 7, my lord.
Yes.
Yes, your lordship. Like in this case, my lord, that myself along with Midul Das, Vikas Bormon, this some person went to the house of the Bhavesh Das, my lord. The PW7 say that Midul Das was with them, my lord, not my lord alone, and the contents of the my lord, PW7.
More important is he did not notice Bhavesh on the day of the incident.
Yes, my lord. And my lord, PW11, my lord. Page 32.
Where was Bhavesh arrested?
Lord, he was arrested, my lord. T13, my lord, your lordship find. Page number 40. Question number 10, my lord.
Right.
10, 14.
So you were arrested near your residence.
When I was returning home, my lord.
Correct. That returning home we will see later on.
Yes, my lord.
First we see you were arrested near the place of occurrence.
Yes, my lord.
Correct. It is so coincidental the day on which your wife was murdered, you were returning home.
Yes, my lord. My lord, kindly come to the my lord. Page number 45, my lord.
45.
Question number 48, my lord.
Yes, what is question number 45?
48, my lord.
What?
48 number saying, my lord, that look Midul Das, on the testimony of Midul Das, Milord, conviction was made, Milord. And Midul Das, Milord, slapped me twice, Milord. About 4 or 5 days before the Kali Puja pandemic, Midul Das demanded a huge amount of subscription from me. I failed to meet the demand. Midul Das slapped me twice at the time. Out of grudge, Midul Das gave me
All
false
right.
evidence.
Take the appellant has assailed judgment and order.
Milord,
dated-
Midul Das, Milord,
Very bad man. Appellant has assailed
he was in custody 8 and 5 years old custody.
life term.
Subsequently, he was granted bail by this court, Milord.
Life term. Appellant, be cancelling the bill, taking him back.
Milord, kindly, Milord.
Yes, sir. Appellant has assailed judgment and order dated
No witness, Milord, nothing, Milord. I mean, Midul Das, Milord, the conversion of Midul Das also, Milord, is not.
17/12/2015 and 18/12/2015 passed by learned additional session judge Mathabanga Kuch Bihar in sessions trial number so and so, bracketed sessions case number so and so, convicting the appellant for commission of offense punishable under section 498A and 302 in the penal code and sentencing him to suffer imprisonment for 3 years and pay a fine of rupees 5,000 in default to suffer rigorous for 3 months more for offense punishable under section 498A IPC and under section and to suffer rigorous for life and to pay a fine of rupees 10,000 in default to suffer rigorous for 6 months more for the offense under section 302 IPC, both the sentences to run concurrent. Prosecution case alleged against the appellant is as follows. Appellant, the deceased, Geeta, was married to the appellant on 11th March 2010 BS. Put it to English shape the other way. At the time of marriage, various dowry and gift articles were various dowry and gifts were given to the appellant. From the wedlock, a male child was born. Appellant was addicted to liquor and used to physically assault Geeta and used to demand large sums of money and physically assault her. Matter was brought to the notice of local people, including the panchayat.
Milord, may I add one thing, Milord? May I add?
Yes.
According to incident, Milord, the incident occurred at 4 PM, Milord. Milord, you will also kindly come to page number 37, IO. Like he was arrested, Milord, at around 6:30 PM, Milord.
All right. Including panchayat authorities. He did not mend his ways and continued the torture. Finally, on 30/10/2008, the appellant assaulted Geeta with a bamboo on her head and fled away. Bamboo on her head. As a result, Geeta died. Appellant fled away from this. Appellant fled away, tried to flee away, but was detained by local people and handed over to police. On the written complaint lodged by Profullo Chandra Das. Profullo is PW?
Profullo, Milord. PW, Milord. 9, Milord. Page number 30.
PW 9.
Profullo local committee member, Milord.
Profullo local committee member, that is Profullo Bormund. Profullo Das has not been examined.
Yes, your lordship.
He died in October. Late brother. Profullo Chandra Das, since deceased. Bokshodanga PS case number 11408 dated 30/10/2008 under section 498A 302 IPC was registered for investigation. During investigation, appellant was arrested. Appellant was arrested. And charge sheet was filed against him. Charges under section 498A and 302 IPC was framed against the appellant. Appellant prosecution during trial, prosecution examined 16 witnesses, and exhibited a number of documents. Defense of the appellant was one of innocence and false implication. During his examination under section 313 CRPC,
Like Midul Das saying, my lord, he was running, and he has seen the, my lord, Bhavedas was running, my lord. But subsequently, my lord, the other neighbor said, my lord, Midul Das was with them, my lord.
correct, we have argued that.
Yes, my lord.
We have taken note of that argument,
Yes, my lord.
sir.
The examination made by the, my lord, the Midul Das is not, my lord, forwarded by the other people.
You are absolutely right.
Yes, my lord.
We have taken note of that. We have taken note of that. During his examination under 313 CRPC, appellant contended he was returning home after work when he was caught on the road and falsely implicated in the case. Good stop. However, he did not lead defense evidence to probabilize his alibi. Good stop. In conclusion of trial, the trial judge, by impugned judgment and order, convicted and sentenced the appellant. Evidence on record. PW 1, 2, three, PW, PW 1, 3, 4, and 4, other relations of the deceased. PW1 is her uncle. He deposed. Geeta was married to the appellant as per Hindu right, married to the appellant. She was tortured by him severely. Number of shalishes were held. Last shalish was held a month prior to death. Appellant used to demand money for his business from Geeta's father, Profullo Dash, since deceased. On the fateful day, appellant assaulted Geeta with a bamboo. She received injuries and died. Hearing the news, PW1 went to the spot and found blood in front of the gate. He also saw a bamboo. He went to Gokshodanga police station, hospital, and saw his niece's dead body. He signed on the inquest report. His brother, he went to the police station with his brother. His brother, one Dulal Dash, PW 16, scribed the first information report. His brother signed on the report. He proved the signature of his brother. Local people had caught the appellant and handed him over to police. During cross-examination, he was unable to say when the appellant had demanded money from his brother, but stated that a sum of rupees 12,000 was given to the appellant. PW 3 is the mother of the deceased. She deposed. The relation between the couple was good for about a year. Thereafter, appellant pressurized Geeta to bring money. He used to assault her. They gave money in installments. There was a shalish. Over the issue. On the date of incident, appellant assaulted Geeta. As a result, she died. Hearing the news, she went to the place of occurrence. She also went to the police hospital where they noted the body of Geeta. We're keeping this tomorrow for orders. At the top, we'll dictate the remainder portion. Other matters tomorrow.